curious what was meant by ornamental, because to me that means art or the way something looks. So I was confused. It sounded to you more like it's a technological term.
It's really a lay term, and by ornamental I don't even mean pretty, but it has to do with the appearance of the design as compared to how it works. So what utility patents are about is structure and function, and they're about utility. They're useful, so it's technology that's useful. Whereas a design patent has to do with just how it looks. There's something neat about it. This particular display right here, it's not really unique, but it's a little different from other displays. I wish I had a better example. This has some functional aspects of it. This little clicker, it fits nicely in the hand. It's sort of ergonomic. You got the HCI people here, right? They're doing ergonomic things. But it's also pretty to look at. So this is probably, and I don't see a patent number on it. Their engineers and management might not have even thought that they made an invention here, but I see 2 inventions at least. There's something, the ergonomic aspects of this are functional and patentable, and it's also neat to look at. So that's just the look at it part of it is protectable by a design patent. And that's all that's meant by ornamental. It does not have to be pretty. It doesn't have to be like a sculpture or something you get a good grade on in an art class. An artificial hip can be protected by a design patent, and nobody sees it but the surgeon. But it's still considered ornamental. Nothing pretty about it. Other questions? In the back.
Oh, up top.
I have a question for you. My name is Hannah Deering. I was wondering if you could kind of comment on just the cost of the patent system for small businesses. Obviously, these huge corporations are pouring billions of dollars into building up their patent libraries and suing one another. But for, say, a small software startup, how can they really afford to innovate and defend themselves if they should come into patent infringement territory?
It's very tough if you get sued for patent infringement. It can cost. It's going to be in the tens of thousands of dollars immediately, and a patent litigation can run that much every month. They can run $100,000 or more a month, and they typically go for at least 2 years before there's even what I call an exit ramp, where you can really settle the case. The courts put the parties on a kind of an automatic schedule, and it's basically make work for the lawyers and the parties. There's a lot of discovery and a lot of motion practice, and you can't find a contingent fee lawyer to defend the case. You have to pay them in cash, unlike a plaintiff's case where you might be able to get a contingent fee lawyer. And I have seen small companies and individuals really brutalized by patent infringement litigation. What I thought you might ask is, how does the startup company fund the patent applications to protect their technology? And what I see there is, for a company that I do a lot of work on medical records software patents, they say that it's very important for them to be able to raise money to attract capital investment. And that's also one reason why countries like Korea embraced the patent system back in the late 1950s when they were just destitute. That was the only way they could attract investment. Because why should people invest in something if they're not going to be able to protect the technology? But you still have to be able to come up with the money. And that means revenues, either investors or better yet, revenues. And I'd like to see it come from the revenue side. So if there's a product that you have launched that you're going to make some money on, or you expect to launch it and you expect to make some money on it, it is an investment to build up a patent portfolio. And even if it's your first patent application or patent, you think of it as the beginning of a portfolio that you're going to build around. As for getting sued, it's just that's a tough fact of life, and that's true in all of American life and all of American business. And sometimes I tell people when they've been sued, I don't think it's much consolation, but I tell them, congratulations, you got somebody's attention. People wouldn't be suing you if you weren't doing anything, if you didn't have anything. Other questions?
I think we should wrap it up with that. Please join me in thanking our speaker, Richard Beem.